We've talked about the ways the executive branch has increasingly taken on legislative-type powers. One of those ways is when presidents make policies through executive order. Another is through the bureaucracy. The 15 cabinet-level departments under the president and innumerable agencies under them have a sweeping role in public policy that has only increased over time.
What exactly is the bureaucracy? Let's talk about how the executive branch is organized. At the top we have number 1, the president. Beneath him are 15 department heads, the Secretary of State, Secretary of the Treasury, and so on, and a few other officials who are considered to have cabinet rank. Number 3, we get to assistant secretaries, directors of agencies, and other people who are beneath secretaries, but still high enough that they must be appointed by the president and confirmed by the Senate. There are around 1,200 positions at this level. Finally, we get to number 4, the largest category by far, ordinary government workers, the civil service. These are people who in general are hired through an ordinary merit-based hiring process and can expect job security even as presidents come and go. They are the long-term career employees. The bureaucracy is not a formal term, but when we use it, it always includes at least number 4, and depending on the context, may also include number 3.
With the growing scope and complexity of the subject matter the federal government regulates, Congress lacks the time and expertise to make detailed technical regulations about every issue. Instead, it often draws the broad outlines of what it wants done, and then delegates the issue to an executive branch agency. It does this by passing what's called enabling legislation to give some department a new power and a mandate with instructions to follow. Then the executive agency, also known as the bureaucracy, fills in the gaps by making rules. Rules are different from laws. Congress passes laws, executive branch agencies make rules. Or if you want to be hypercorrect, they promulgate rules. Promulgate. As commentators have pointed out, for some time the sheer amount of law made by agencies has far outnumbered the lawmaking engaged in by Congress through the traditional process. For instance, while in 2016 Congress passed 216 laws, slightly above average for the Obama era, federal agencies issued 3,853 rules, totaling almost 39,000 pages. On average, the bureaucracy promulgates 20 rules for every one law Congress passes. And some of these rules can be as significant, if not more so, than traditional laws. The Clean Air Act has a provision passed in 1970 that gives the EPA, the Environmental Protection Agency, broad power to regulate air pollutants. This is before anyone was aware of global warming. At that time, pollutants probably meant things like sulfur dioxide, which was responsible for acid rain, or other air contaminants that had a direct impact on plant or animal health. But Congress doesn't specify that. It leaves the statute broad, giving the EPA power to fill in the gaps. Now, fast forward 40 years to the Obama administration, when the EPA decides it's going to regulate carbon dioxide and other greenhouse gases as pollutants. The EPA creates something called the Clean Power Plan, which essentially is designed to shut down several coal-fired power plants and prevent more from being built. You have a Republican Congress that's completely against this, that wants to protect the coal industry, and thinks the EPA has wandered outside its original mandate. So what can Congress do? It's given away this power. Can it take it back? The short answer is probably not. You see, Congress is sort of in a bind. As Justice White pointed out, it has to delegate power, or it leaves itself with the hopeless task of writing laws with the requisite specificity to cover the entire policy landscape. But once it passes a law delegating power to the bureaucracy, in order to overturn any bureaucratic decision, it needs to pass another law, which means the president would have to sign it. Why would the president sign a law overturning a decision made by his own bureaucracy? He'll veto it. So doesn't that mean it takes a 2/3 vote of both houses to repeal any agency rule? Congress was aware of this problem, and so when the bureaucracy was first being created during and after the New Deal, Congress was willing to delegate power, but with conditions. It wanted to make sure that it could still repeal any rules it didn't like. And so a legislative veto was inserted into most enabling legislation that let both houses of Congress, or perhaps even one house, veto bureaucratic decisions without the president's input. Presidents reluctantly signed these laws because even though they weren't fond of the legislative veto, it was still worth it if that was the cost of enlarging the bureaucracy. But then we get to the case of INS v. Chadha. Okay, Chadha was in a truly unusual position. He was born to Indian parents in Kenya when Kenya was part of the British Empire. He went to study abroad at an American university. While he's studying abroad, the British Empire splits apart, Kenya and India gain independence, and when he's done with college, he has no country to go home to. India won't take him because he was born in Kenya. Kenya won't take him because he has Indian parents. And Great Britain won't take him because he has no connection to the British Isles. So he's left stateless and just remains in the United States, overstaying his visa. That means he should be deported. But the INS, which at that time was the agency that regulated immigration, considered his case. They gave him an exemption because of extreme hardship, sort of like a pardon for immigration offenses. So he can stay in the United States. There's just one problem. Congress, or at least the House, thought Chadha should be deported. And this matters because the enabling legislation for the INS reserves to either House of Congress a veto over INS decisions. So the House of Representatives rules to reverse the INS, and it seems like Chadha will have to be deported after all. But Chadha challenges this in court, saying the so-called legislative veto is unconstitutional. The court agrees. Only a regularly enacted law that goes through the Article 1, Section 7 process of bicameralism and presentment can overturn a rule. Of course, this means that few executive branch rules will ever be overturned. The court is aware of this and basically says, we don't care. Although the legislative veto has doubtless been a convenient shortcut, the fact that a given procedure is efficient, convenient, and useful will not save it if it is contrary to the Constitution, in the words of Chief Justice Burger. In this case, it means that the INS has the final word, Chadha gets to stay. Now, at the time of Chadha, there are over 200 laws that have legislative vetoes included in them. Are they all cast into doubt? Congress has still acted from time to time as though it has a legislative veto, and presidents have usually shaken their heads and said, no you didn't, that's unconstitutional, and then kind of gone along with Congress anyway. So we don't really know.
For decades, it looked like the long-term trend was that the bureaucracy would go on forever accumulating more power. With the legislative veto mostly gone, it seemed there was no natural counterweight against the bureaucracy. Until roughly 2020, this is where I would have ended the story. But around 2020, a new chapter began. Remarkably quickly, the Supreme Court decided a line of cases that created a giant new area of constitutional law called the Major Questions Doctrine. The Major Questions Doctrine is the principle that an executive agency must point to a clear congressional authorization to justify any act that has major economic or political significance. Courts will presume that Congress has not given an agency power to act concerning a major question, unless the statute clearly says so. As the Supreme Court has put it, we expect Congress to speak clearly if it wishes to assign to an agency decisions of vast economic and political significance. A landmark case was West Virginia versus Environmental Protection Agency. In this case, the Supreme Court said the EPA did not have congressional authority to create the Clean Power Plan, which we mentioned earlier in this lecture. Chief Justice Roberts criticized the EPA's actions, saying, EPA claimed to discover in a long extant statute an unheralded power representing a transformative expansion in its regulatory authority. It located that newfound power in the vague language of an ancillary provision of the Act. and the agency's discovery allowed it to adopt a regulatory program that Congress had declined to enact itself. The following year, the court took another swipe at agency powers. In 2023, the Supreme Court decided Biden v. Nebraska, striking down the president's student loan forgiveness program. President Biden's Department of Education had attempted to cancel $430 billion in student loan debt. The agency believed it was authorized to do this because of the HEROES Act of 2003. Part of the act allowed the Secretary of Education to modify statutory or regulatory provisions concerning student loans in connection with a war or national emergency. The argument was that the COVID-19 pandemic was such a national emergency, and economic disruption caused by the pandemic was a sufficient reason to cancel student loan debt. The Supreme Court said, no way. Again, the Chief Justice weighed in on agency power. The authority to modify statutes, wrote Chief Justice Roberts, allows the Secretary to make modest adjustments to existing provisions, not transform them. A clever sentence by Justice Scalia is often used to summarize the major questions doctrine. Congress does not hide elephants in mouse holes. If Congress really wanted the Department of Education to have power to cancel student loans, it would say so directly. It would not hide such an elephantine power in some small corner of the statute, where you can kind of see the authorization if you squint at it hard enough. At this point, it seems that the major check on the bureaucracy may not, in fact, be Congress, but instead the federal courts. Again, this is a recent development and highly controversial. Both West Virginia v. EPA and Biden v. Nebraska were decided on party line votes, with the Republican justices voting against the agency rules and Democratic justices supporting the agencies in question. Left-leaning jurists question the need for the judiciary to insert itself into this area at all. There is a fear on the left that these cases may be the start of a sort of new Lochner era, where the conservative courts go on a wild crusade striking down agency decisions. Left-leaning scholars have called the doctrine a judicial power grab, with one writing, "The judges are out of control." Republicans, of course, counter that perhaps it was the Biden administration that was out of control, and courts are restoring balance to the system. In fact, let's close with a look at the partisan politics of agency rulemaking. During the 1970s and 80s, the political dynamic was something of the reverse of the current day. In that era, Democrats had long-standing control of Congress, while Republicans kept hold of the White House. During this time, favoring broad grants of power to the executive branch was seen as the conservative position. Today, however, Democrats have emerged as the party that supports executive agencies having more power. Democrats tend to have higher trust in institutions and prefer decision-making by qualified experts who work for agencies. You often hear Democratic politicians say things like, "Trust the scientists." For example, Democrats were far more willing to take the advice of health officials at the Center for Disease Control. With severe veto points in Congress, executive branch rulemaking emerges as one of the best ways to enact progressive policy change. Furthermore, it should be said that government workers are one of the most consistently Democratic voting blocs in the U.S. population, so Democrats may be naturally comfortable allowing these government workers to make more decisions. Republicans, on the other hand, have emerged as the party that favors judicial checks on agency actions. Republicans are typically concerned about excessive regulation, and they put more value on blocking unwanted rules than promulgating new ones. In addition, Republicans have a 6-3 majority on the Supreme Court and control many circuit courts, which makes them more likely to trust judges to block agency rules. Overall, only time will tell whether the major questions doctrine serves only as a means to swat down the most excessive agency actions, those that are a real stretch, or whether judges will make deep cuts into the administrative state.